Hey everybody, I'm Greg Siskind. I'm joined by Aaron Hall. Jesse Bless is on an airplane, even though I guess that you can get internet on airplanes. Not quite good enough for live streaming yet, and he would obviously disturb everybody around him if he participated, and this probably get ejected from the plane. And then we have Chuck Cook, who I was texting with this morning, is still in recovery from medical leave, and we've got a few more weeks left without Chuck. I don't know if Chuck's tuning in, but he probably has other things going on, so maybe not. But anyway, welcome everybody. Aaron and I will be covering for today. We'll talk a little bit about our cases. Not a ton of news to report on any of them, but we'll try and address them. And then, and probably because of also, I guess, the holiday, I guess that there's decisions and filings and things like that slow down whenever people are taking a long weekend. And then we will also talk a little bit about some immigration news this week. Also, nothing earth-shattering that's going to affect most of you, but some interesting things, interesting developments. Anyway, Aaron, let's get started. And since we're doing this through my my live stream channel and not Chuck's, so I don't have all of the banners all pre-configured and everything like that. So we're just going to have to tell people which cases we're talking about, and they're going to have to remember on there. So the first one, let's talk about the I-601A case. That's the one with the most plaintiffs that we have that we're working on right now. But that one is basically in kind of a wait and see mode while we're sort of helping out other cases that are in the pipeline. But is there any news to talk about? And I will talk about data in a second on that case.
Sure.
In terms of actually court stuff.
Yeah. So last week we mentioned that we were going to be filing a notice of supplemental authority, and we did that. And basically what we had to tell the court was that we recognize that the case has actually stayed, and so we understand that they're not actually going to be ruling on anything until the Ninth Circuit makes its decision in Mercado. But we said, even though it's stayed, we want this new case Granados out of the District of Colorado to be before the court, and so we filed it. And Granados, to remind you, is the case where the judge found in a case with, I think it was 25 601A plaintiffs, that the court does have subject matter jurisdiction, and wanted the parties to get together and figure out to what extent discovery was going to be needed. Which is exactly what we eventually want the court in our case to do. So we filed that last week. While I'm on the notices of supplemental authority, before you get to the data, we filed a similar notice in the 601 case in Nebraska. The same case, the Granados case out of Colorado, because even though the Granados case was about 601A cases, the legal issues about jurisdiction are largely the same. So we wanted that to be before the Nebraska judge as well in the 601 case. That case, we could get a decision on the motion to dismiss at any time, or they could schedule an argument, a hearing if the judge wants. So that one could have action soon. The 601A case in Washington, we're actually formally in a holding pattern while we wait for the Ninth Circuit to make a decision.
I think the one common theme we've seen, Aaron, from some of these cases is that the government wants to push everything it can to prevent a judge from getting to the real issue in the case, which is, are these delays excusable on there? And they'll argue that you filed in the wrong court. They will argue that the judge doesn't have the authority to make a determination on the issue. They never want to actually get to the issue, though, which is like, is it reasonable of what they're doing, and is it acceptable on there? And I think it's telling that in a lot of our cases, they're trying to steer as far away as they can from the heart of the case and trying to take them down on procedural grounds like this. So we'll see. It's encouraging when judges call them out on that. They may not. The judges may even actually be sympathetic with them that they do have a case to make, as far as whether what they're doing is reasonable on there. But but not be okay with the with the shenanigans, basically. And unfortunately, a lot of judges, I think, are loaded up with matters and are thinking less about justice and more about how to get their workloads under control, which is sad. But hopefully, judges in our cases will give us our day in court, as the saying goes. We did actually have a couple of more cases approved over the last few days. So, as you know, we track every one of these cases and where they're moving, and I can tell you, we are at we're 28 now, and that is, I guess, about 10% of our cases have had approvals, which is obviously not enough. But what I can tell you that was interesting is the new cases that got approved. One was filed in September 2019, and that makes sense because that's one of our oldest cases. But the other two were there. We have quite a few cases that were filed, where people filed before. One was February 2020, but another one was July 2020, and that is the July 2020 is pretty telling because we probably have at least, probably 25% or more of our plaintiffs have filing dates that are older than that on there. So it does tell you there that they, this idea that they are working cases in order. That's something that they always claim to the judge, that if they give our plaintiffs relief, that somehow they're going to be jumping the line. They're not even adjudicating our own cases in a time and using that same argument. So I think that's something hopefully that we'll be able to impress on the judge. All right, Aaron, anything else on 601A?
No, I don't think so. That covers it.
And you mentioned the notice that you filed in the 601 case. Any other news on that one?
Nope. Now we're waiting for the judge to take some action there.
All right, and as unfortunately is the weekly theme, we don't have any news on Go or Gomez or any of the DV cases at this point.
If I remember right, I think oral argument was September 14th last year. So we are, looks like we may actually hit a full year from oral argument before a decision, which is crazy to me. But
it will be really regrettable if we don't get a good decision on it. And I guess I'll be forgiven if they give us, what we're asking for. But it is it is striking how long that's taken on there, and it's, it could be that they are really grappling with the issues. It could just be, that they have other things that are taking priority. But it is, I don't know. I'd be curious, probably talk to a law clerk and find out a little bit more about what sort of why a case might be taking so long on there. They're usually not afraid. I mean, grant it is in the DC circuit, and that is the insurrection circuit. So they have 1,100, which is incredible. It's the biggest criminal case. I mean, the biggest number of criminal cases stemming from the same incident in the history of the country.
Wow, I didn't know that.
Yeah, so they have these 1,100 cases, and I guess that is, in terms of prioritization, obviously they're criminal, which means that since people are going to jail, and it's also an insurrection, that it's hard to argue why they would, about whether they should be prioritizing those cases. Of course they should. But they don't add judges, and they don't add capacity really that much to be able to take on that extra load that they're dealing with right now. So that would probably be my biggest guess, is that everything is slowing down. But I would like to probably chat with some other lawyers in other cases and find out how many of them are delayed by that, like this. So that's something that would probably be a good little research project for us. All right, so that's DV on the Ukraine case. Not real. Is there any news since last Wednesday on that case? I'm not thinking of any.
No, I don't think so. With the motion is the motion to dismiss or transfer venue is before the court. So
Yeah, I mean, I think the big issue for a lot of people is sort of like what's going to happen with the Ukrainian. Well, two things. Are they going to extend? Where September 30th is the Uniting for Ukraine program expires. Um, so no, it doesn't expire. I should say it continues, but the supplemental expires. That gives automatic work authorization to people coming in. So after September 30th, that they haven't passed anything, then it's going to revert back for everybody that enters after that date. They're going to have to file an I-765 and go through that process. However, there is an extension bill, and it would, it's controversial because there are a lot of Republicans who are trying to block anything for Ukraine because they're such patriots, I guess. On there. But that being said, so there's some uncertainty surrounding that. We do have an extension. We did have a redesignation of Ukraine, however. So I think for Aaron, there's no reason why somebody can't pay simultaneously TPS and parole, correct? I think you can. And I think you could have a non-immigrant visa. You can have all three of those. I mean, you can have multiple things at the same time.
Yeah, and I think
I know I've had TPS and J. Like we used to have doctors that were, when TPS would come out, we would be able to keep the doctors in J1 status and simultaneously have them in TPS. So I'm pretty sure that you can. I don't see any reason why your parole status would be affected by TPS.
Not that I can think of.
So travel might be a little tricky as far as which one you come back in on, but I think I would apply for TPS. I think is a better category just because the president has a lot more discretion over it, and they have a long history of renewing TPS. It's very rare that a TPS program, once it started, that they close it down and send everybody home.
Right.
It's happens, but it's very rare.
And it's hard to see that happening anytime soon.
Yeah. All right. So that's Ukraine. Any other cases we want to talk about? I think that kind of runs through the list. I know Chuck always says these EB5 cases, but I have not been up on where we are on those cases.
I don't think there are any updates that I know of. So.
Okay.
Yeah.
Regarding immigration news, we do have a new TPS designation this week for South Sudan, which was good news. I don't think there's a big population in the U.S. of South Sudanese, but nevertheless, it's good that that's recognized what's going on there. The other thing I think that was interesting, Aaron, because where the immigration bar was involved in litigation on the issue of the public charge rule that came out during the Trump years, and litigation was able to stop that horrible rule from ever taking effect, at least widely. And it was going back and forth between courts letting it proceed and courts shutting it down. But DHS released their version of a new public charge rule a couple months ago, but Department of State issued a rule this week, and in it they said, we're not doing the 2019 business, and we're going back and taking the pre-2019 policy and turning that into a rule on there. So that's how they're dealing with it. But anyway, it's immigration lawyers that are listening to us that say something to keep an eye on as far as that goes. But the good news is they're not applying the Trump version of public charge, but it'll be something that's going to presumably affect how we prepare our cases. Any other news court news or anything else that's worth mentioning?
I don't think so.
We can get to some questions.
Let's get to some questions.
Okay. We got some hellos.
Oh, and as you read through those questions, there's a couple in there that are wishing Chuck a speedy recovery and saying that people are thinking about him and praying for him, and I know that he appreciates that. So thank you.
Yes, I will make sure that we'll both make sure that he gets that message. All right. It's case specific, but 2 pending cases and filed a writ of mandamus and loss. Can you file a new one after 1 year. So that's an interesting question, because you could lose a mandamus case because the judge says not enough time has passed, and then you wait more time and you file again. And it's not like a statute of limitations on, or I mean, not a statute of limitations. It's not like you're one and done on mandamus. If the judge just said, I mean, it depends, I guess, on how the judge ruled. If he says that I don't have the authority, that's different than saying I don't agree that too much time has passed. So I think part of it is what the reason was for the loss, Aaron. But let's just say you filed it after 6 months. The judge says we need more time. Then you wait 2 more years, and you still don't have a decision. I don't see a problem with filing another mandamus case if it in fact that was denied because the judge said it was too early.
Yeah, I agree. It depends on whether it was a ruling on jurisdiction or a ruling on whether the delay was reasonable.
Yeah, and I think this question about filing after, like how much time should pass before you do a mandamus, I think if you talk to 10 immigration lawyers, you'll get 10 different answers on that, because it's really subjective. It's really what's reasonable. What's reasonable is a subjective determination, and it's basically what can you convince a judge is reasonable, and and there's not a hard rule on that. For most cases, there are a couple of cases that have statutory deadlines as far as when things need to be adjudicated, but assuming that we're not talking about one of those kinds of cases, is a year enough? I think it really depends on sort of what's normal, how complicated the case is. What we usually in our cases set a timeline for at least a year. I think we've done that, but sometimes longer. We've added on our case just to make it, the cases that are being filed in our mandamus is just stronger. But I think there are a lot of factors that would go into it. I think a year is generally long enough, but it's for a lot of the cases that we handle, but it would definitely, I think, not be wise for us to say 1 year is a consistent across the board rule for what's a good idea as far as when to file. And in some cases, you may want to wait anyway, because there may be for some reason or another, case might be getting stronger or new evidence coming in or something happening. But Aaron, I don't know if there's anything more to add on that.
No, I think it's case specific. So you should consult with your lawyer, or you're welcome to reach out to one of us as well.
Okay. Good morning. Thanks for updating. Hello, Norma. All right. Any information about DV? We just talked about that. It's just, I think, the 1 year date might be significant in the judge's minds, but like I said, we're going to do a little research and see if we can figure out what's happening with all the other cases that were basically argued over the last year, and are they taking longer on those cases too than just ours. Not that we can do anything about it really, even if we found out that that we were the only one that's taking this long, because there's just no real, the judges just have all the power here. So and we're just going to have, unfortunately, we just have to live with that. Okay. Are we aware of mandamus suits for 601s that are not getting automatic motion dismissed? To clarify, has anything changed since our lawsuit on the individual lawsuits?
As far as I'm aware, and I'm certainly not getting notices on every lawsuit filed around the country. As far as I'm aware, they're filing a motion to dismiss on every case that I've seen, with the same arguments.
They don't want a judge issuing an order that says 4 years is unreasonable. That's what they're trying. They're trying to, like I said, earlier on, they are trying to avoid as much as possible getting to the heart of any of these cases. So if they don't do that, and they have to actually, they can either settle them, which might be happening and we're not aware of it. But we're not, I would doubt it. And they're trying to
possible, but my expectation is that they already have these arguments drafted. They share them amongst themselves. And so it's not too big a lift for them to file the motion to dismiss in any individual case. And as far as as far as I'm aware, they're doing it every time. And I think that's because their client, USCIS, has told them to, has told them, we don't want to participate in settling these if at all possible.
Yeah, I mean, they've had this mentality that if they fight back on all, across the board in all these cases, it's going to dissuade people from suing them. But I mean, the numbers show that the opposite is happening on there, that they're putting so much resources into fighting instead of adjudicating, that it's only encouraging more cases to be filed. We will pass that on.
Thank you, Tiffany.
Okay, so this is a common thing that we've seen, multiple transfers. And what we are not clear on is whether these cases are really ever physically being transferred. And also whether the codes that are showing up online are actually reflecting where these cases are. So what we can tell you is this: they have been moving the 601A caseload to a different service center. It is a service center, but it's a virtual service center, which means that it is separately organized. It has its own chain of command, but all of the examiners are the same examiners in the same locations that were working for Nebraska and for the other service centers and they've been reassigned as remote employees for this virtual service center. So a couple things have happened on the 601As. One was, we know that they've had this mass digitization process where they're taking all these cases and they're scanning them in. And we know that it's showing up in the cases as being transferred when they're sending them out for scanning. So that's one thing when they say the case has been transferred, that's happened. And when the scanning's done, it shows up as being transferred again. I think that's one of the things that's happening. And then the other is when they actually move it to this, when they move, I don't know whether once it's been digitized, it could be staying with the same examiner, but they could also be moving it to a different examiner, which is a lot easier to do after it's digitized, because all they're doing is basically, changing the name of the officer and an assignment in the system. So I'm not as worried about the transfers, like they're putting it into a box and shipping it across the country, multiple times for each of these people. I think that might have happened. That might happen once or twice in the course of the adjudication of the case, but I don't think that that's what's happening here. But Aaron, I don't know if that's how you're reading it.
Yeah, it's a.
They're not transparent at all in what's going on, and that's part of the problem here. Is that they leave everybody to jump to their own conclusions and come up with their own theories of what these codes mean.
Yeah.
And that's why we need discovery, so we can figure out exactly what's going on. Let's see. Each notice is speed up processing. It feels like they're playing hot potato with my file every few months. Yeah.
That's that's the boilerplate language on a transfer notice. Everyone's going to say it's done to speed up processing, so I wouldn't read too much into that.
Aaron, you have an answer on this one?
Mm-mm.
Neither do I. Sorry. Okay. Past citizenship test. Congratulations. Still haven't gotten any updates. So that's a question that's very specific in a lot of cases to the jurisdiction you're in. I can tell you that in Tennessee, but I know it's in other places as well, we will find that a naturalization interview will happen, and there might be a lag time of a while. And sometimes there could be some innocent reasons for this, like judges like to do the ceremonies, and the judges' vacations or schedules are busy during the summer. So they are not doing as many ceremonies as they normally would do. And they have a capacity in terms of the amount of space in the courtroom. So, it's could be something mundane like that. We had one instance where they were holding everybody up because they were wanting to do this massive 4th of July thing at a baseball game on there. I mean, so sometimes it's stupid things like that. It's not stupid, but I mean, like you get the point on that. But it also might, sometimes it depends. Sometimes USCIS officers, I guess, can do the swearing in too. And it doesn't necessarily mean there's a problem. 7 weeks is a while to not get notified when your swearing in is happening, I guess, but maybe not. I don't know what's going on in Denver.
Well, we are very lucky in Denver in that almost always right now, that's maybe a little strong. Usually right now, they're offering to swear you in at the interview if they can approve your case. The officer just has you stand up and they print the certificate right there. It's pretty cool. Or you can be scheduled for a ceremony with friends and family. But the way I read the question, we're not sure if the application is approved.
Right.
And the question, any actions needed, probably I would say no for now, but just keep in mind that if 120 days pass from the interview, then you're allowed to seek review from a court.
So that's true. All right. So I was not reading closely enough on here. So you say still not approved. I mean, approved meaning that the N400 was like basically okay for you to then get sworn in, or you haven't actually gotten that notification yet. So yeah, I mean, it might be enough just to kind of make an inquiry to kind of wake things up. But if you don't have any, the examiner will usually tell you. Aaron's right. I mean, the examiner, at least in Memphis, will usually tell you that everything was good and that they're going to, then the next thing you're going to hear is about swearing in. But that's it's not clear from your question whether that's your situation or not. Okay. I'm not sure. Medad's asking a lot of questions about his case and his mom. I think it's probably not a good case to talk about it probably on a live stream. But in terms of sending an email directly to Director Jadu, which is part of your question on there, I think you can do that. I just don't think it's going to matter on a case when you're trying to get that done. If anything, I mean, in terms of trying to, but Aaron, it's part of this thing about getting cases unstuck or getting things, when there's emergencies and things like that. And then a couple of things I would say. One is that, you members of Congress are not as helpful as they used to be because the agency doesn't really give them as much respect and deference as they used to. I hate to say it, but it's true. Sometimes the ombudsman's office can be helpful. Obviously you should exhaust what you can from customer service, and document it. That's another thing is whenever you have any interactions with USCIS, whether it's Emma or whether it's the customer service line, keep a log of dates, who you spoke, if you, and short notes about what the conversation was regarding on there, because at some point later on, if you actually get to court, it's important to be able to document that you tried to fix this on your own and USCIS wasn't helpful. All right, we have a question from Mohammed on the.
I think that one's a repeat.
That's the same one. Sorry, I posted that more than once. Sorry. All right.
I can take this. So this is a question about why would they stay our case, our 601A case, for this other case if it was a filing in 2022, where our filing is predicated on people having been waiting generally longer. The reason, Luz, is because there's a threshold issue or an initial issue that the court has to decide, and that's whether the court has the power or the authority to even get into whether it's an unreasonable delay, whether it has jurisdiction to do that. So what they're trying to decide is, are we blocked by a statute? Or is the court blocked by a statute from even looking at whether it's an unreasonable delay? And if the answer is no, which it should be, that they're not blocked from doing that, then the individual courts, the district courts, will look at those cases and say, is that reasonable? Is that amount of time reasonable? And in our case, is a longer amount of time reasonable? But the initial issue about whether the courts even have the authority to look at this is the same in the case up at the Ninth Circuit and in our case. And that's the reason that our judge has decided to wait and see what the Ninth Circuit says about that case.
Okay. So Dr. Almadani said that he passed but the case is not approved, and he said that the officer said he needs to review the file. So in that case, Aaron's answer on the 120 days is actually the relevant. So
and I can't. Yeah, I was going to say obviously I can't speak to the specifics of your case, but I can just tell you in general. When I'm talking to a client about a naturalization interview, I tell them, we can't expect a decision at the interview and it could be for lots of reasons, some of them out of your control. So it could be that you have a new officer who has to go get supervisor approval before making a decision on any case. It could be that you have a big file and that they have to review your file because part of the naturalization adjudication is basically double checking and making sure that the person got lawful permanent residence in a legally correct way. So it could be that they have to review all of that or do that with a supervisor or run it by legal. So there's lots of different reasons that
I'm one thing, just totally speculating on here, but I've just seen it with doctors. If you were a J1 and you got a J1 waiver and then an H1, you kind of have that whole history. We have seen naturalizations delayed while an officer tries to go back and verify, for example, that you actually did the 3 years of J1 service, post waiver service, or you went home for 2 years if you said that was part of, so that's the only. I'm just totally speculating because you're a physician, but if that's your history, that could explain a little bit about what a delay in a naturalization might be about.
I had a case maybe a year ago where that was the issue, whether the 2 year foreign residence requirement applied. And the first thing I did was get on the phone and call Greg because he's the expert.
Yeah, the weird issue that seems to come up in naturalizations, and I warn doctors, it's come up a few times in the last few years, and it used to come up more a while ago, but national interest waivers for doctors. So this program, this physician national interest waiver program, where you have to work for 5 years in an underserved area and it can qualify you for permanent residency. And USCIS would approve, they were issuing green cards like prematurely before doctors had finished. And it was like trying to convince somebody to it was like I had to pry the green card out of their hands because it's like it was like, you're going to get nailed at naturalization if we don't get this fixed, and you need to revert back to pending status because they made a mistake, and just it's not like a bank error in your favor. It will come back to haunt you, and they don't take responsibility for their mistakes. They make you take responsibility for their mistakes. I've seen that happen, and then I've also seen like this instance where people did not they were able to change to H-1B status or change jobs before they had finished up their 3 years of service. So it's sort of like you're on the honor system to some extent earlier on in the process, where they may not check things that closely, but naturalization is sort of their last opportunity. And I have seen doctors not only not get naturalized, but have them basically their whole status called into question and end up in a complete mess because they were found that everything got approved incorrectly that led up to that point. Don't mean to scare you. I hope that's not your case. You have more information. I was long because I had a J1, then got a hardship waiver, then started NIW, then finally got green card. Yeah, so there's just a lot of things that they're probably going through your history to. I mean, assuming everything was done correctly, you don't have anything to worry about. It's just that the officer needs to. It's a large file. There's a lot of things that they need to check. Hopefully, I don't want to say not to worry, but that's probably just speculating probably what's going on. Okay, we've run out of questions. And it was a kind of a light news week with the holiday. So we will be back next week. And Jesse will hopefully be joining us. Like I said, Chuck will not be here probably until our first broadcast in October. Although I know Chuck, he seems like I can't see him staying out that long. He's probably going to get antsy. But his doctors have told him wait till October on there. Anyway, we'll see him soon, and we're keeping in touch. So until next week, everybody have a good couple of days. And if there's big news, look for social media posts, probably Twitter and other places.
Thanks all.
Bye-bye.